May I please, Lordship?
Yes.
My Lord, I beg to mention item number 10, my Lord.
Item 10, yes.
Yes, my Lord. Today, my senior, he could not attend the court today. I pray that item number 10 may be fixed on 31st of this month.
21st of August.
31st.
31st.
Yes, my Lord.
No, not on
Or else
30.
after,
or otherwise
after a
August.
week. Okay, my Lord. First week.
Yes, first week. Learned Counsel, Mr. B. Soto, making a submission on behalf of the leading counsel, Mr. A. Zo, prays that the matter may be listed on 4th
Okay, my Lord.
August, as the learned senior counsel is indisposed.
Yes, he left for.
Indisposed. So list on 4/8.
Lordship,
Yes.
and for the petitioner in item 11.
Item 10.
Item 11.
10 and 11.
Okay,
yes,
they are
analogous.
analogous. Okay. No objections? Learned Counsel for the petitioner, Ms. Such and Such is present for the petitioner in criminal petition 7 of 2026 and has no objections. Yes.
Interim may be
Much
continued.
The interim order passed earlier shall continue till the next date of listing. Yes.
Obliged, Lordship.
May I please, Lordship? Lordship, I beg to mention item 19, Lordship.
19.
Lordship.
Yes.
Lordship, on the previous occasion, notice was returned for all the respondents as
Returned.
yes, insufficient address. So we couldn't address the address, Lordship. So notice may be issued through paper publication, Lordship.
On all the respondents.
Yes, all the 3 respondents, Lordship.
Okay.
Through local dailies, Lordship.
Learned Counsel for the appellant, Mr. L. Pom, submits that the service on the respondents had returned unserved due to insufficient address. Stop. The appellants are unable to get the proper address, and accordingly he prays that the appellant may be permitted to serve notice through substituted summon by publication in a local daily. Stop. The prayer is allowed. Which Nagaland daily or
Nagaland, Lordship, Nagaland dailies.
the prayer is allowed? The learned counsel shall take the steps accordingly and file an compliance affidavit within
After 4 weeks, Lordship.
compliance affidavit after 4 weeks. Yes,
Obliged, Lordship.
this after 4 weeks.
May I please, your Lordship? Lordship, I beg to mention item number 23.
22.
Yes, your Lordship.
Yes.
Lordship, on the last occasion, it has been returned as insufficient address. So we are yet to ascertain the address, correct address. So kindly drain some time
For which
to
respondent?
ascertain. Respondent number 1 to 3. All the respondent.
Learned counsel for the petitioner, Ms. Sayakrilo, submits that the notice on respondents 1 to 3 had returned unserved due to insufficient address. She therefore prays for some more time to ascertain the correct address. List after
4 weeks.
4 weeks. List after 4 weeks. Yes.
Obliged.
May I please, Lordship? Lordship, I beg to mention item number 8.
8.
Yes, my Lord. I'm making a mention on behalf of Principal Counsel for respondent number 1, Gauhati. My Lord, here we are to receive an instruction, so I brief for 2 weeks'
You're
time, my Lord.
mentioning on behalf of?
Gauhati CTC for the respondent number 1.
Yes.
Your Ladyship, I
Yes.
appear for the petitioner in this
Petitioner,
matter. Respondent number 2 and 3 are the relevant respondent. They have already filed their reply. This is a PF matter. They are representing Union of India. 2 and 3 are EPFO and the concerned officer. File their reply. We have filed the rejoinder also. Since 1 year, EPF respondent 2 and 3 had taken time to file reply. On the last date, Your Ladyship, this Honorable Court said that it will be put up for arguments. Your Ladyship, we are outstation counsels, Your Ladyship, we were never informed also. We object to this adjournment. And they are not, they can adopt the reply of respondent 2 and 3. There is nothing specifically prayed against them. It is a PF matter. The main contesting respondent are 2 and 3.
2 and 3.
Lordship.
We have also filed a rejoinder to their reply, Your Ladyship. Pleadings are complete.
I think it is not necessary for you to file affidavit, isn't it? Even verbal submissions will do.
Then, my
If
Lord,
you get
if my
verbal
Lordship is in
instructions.
this, if my Lordship is in this observation, then if this matter will be fixed in the presence of the Principal Counsel, then my Lord.
The problem is the CGC is not present today.
My Lord.
He's on leave. I think he has also applied,
Yes, ma'am.
yes,
The same
it's
has been
also
reflected.
in the cost list also.
Your Ladyship, then
21st to 25th.
at least my formal objection may be recorded
Yes,
in
yes,
the
of
order.
course. You give a date then. And in any case, today it may not reach also because items 1 to 3 will take time. You give your convenient date.
Also,
Learned counsel for the petitioner, Mr. Akash Singh.
indeed,
Akash
Your Ladyship.
Singh is present. So, learned counsel for the respondent number
2 and 3.
2 and 3, Mr. L. Pom is present. Mr.
Jingjang Pom, ma'am.
Ching Pom,
For
learned
Yang
counsel, mentioning on behalf of the learned CGSC, Mr. Yangarwati, submits that Mr. Yangarwati is indisposed and has given a leave of absence from 21/7/26 to 25/7/26. So accordingly, he prays that the matter may be listed on another date. So at this stage, the learned counsel, Mr. Akash Singh, appearing for the petitioners, has submitted that the main respondents herein is the respondent number 2 and 3, who have already filed their affidavit in opposition, and a reply has also been filed by the petitioners. And accordingly, the matter can be taken up without the counter affidavit of the Union of India / respondent number 1. So, however, this court is of the view that since the learned CGC is on leave, the matter may be fixed on another date. So, list on
25th of August, if that's
25th.
of August, Your Ladyship.
25th of August 2026. So, on the next date, the learned CGC shall make verbal submissions if the written instructions are not received. If instructions are not received in order to file the affidavit in opposition. Stop.
Interim to
Yes, we have already
Your
stated.
Ladyship, interim order to continue.
The interim order passed earlier shall continue till the next date of the state. Yes.
Obliged.
My Lordship, I have a similar prayer in item number 12.
Yes,
My
my
12.
Lordship, may I mention item number 12, we are for the petitioners. We just received the counter affidavit by the state respondents only yesterday. So I'm just praying for 4 weeks' time to file rejoinder.
4 weeks.
Yes, Your Lordship.
Learned
My
counsel.
lord,
Yes.
due to typographical error, one slight changes is to be made. If I may be allowed to correct the affidavit.
Changes where?
There are 7
Oh, in
running
the
pages
affidavit.
in my affidavit. Just one word, I is missing. Instead of parity, party is stated. So if I may be allowed to correct.
Yes, that you can put in by hand also. It's
much
okay.
better. Much.
I, you have to put in an I.
Yes, ma'am.
Learned counsel for the petitioner, Mr. S. Das, is present. So, learned government advocate, learned additional AG, Mr. L.T. Sanctum is present, and Mr. Chingang Pom is present for the learned CGC for respondent number 5. So, it is submitted by the learned counsel for the petitioner that a copy of the affidavit in opposition filed by the state respondent has been received, and he would like some time to go through the same and to file a reply if so advised. Stop. List after 4 weeks. Stop. Learned additional advocate general also prays that he may be allowed to make a correction in the affidavit in opposition. When did you file the affidavit in opposition? In the affidavit in opposition, which was filed on 27/2026. In as much as the letter I is missing
In para 7.
in para 7. So the registry shall allow the learned additional advocate general to correct the same by inserting the letter I. So list after 4 weeks. Do you want the date?
Yes, Your Lordship. Maybe 25th is, if Your Lordship, 25th of August.
Okay, 25/8, huh? 25.
Yes, 27.
Oh, 27, no, 27, okay, it's a Thursday, yes, yes. 27/8, okay, yes.
I'm grateful.
May I please, Your Ladyship, I beg to mention item number 6.
6.
Ladyship, as per the information, the AG has settled the matter. I am appearing on behalf of the lead counsel for respondent 1 and 2. As per the information, the pension matter has been settled. However, we are yet to receive the officially the relevant documents.
No, but petitioner should know if it's a,
No received any communication from
no
the government.
communication.
I've been informed from the council that the matter has been settled at AG, and now it is to the government to finalize.
Lordship, for the respondent number 3, I'm appearing on behalf of my senior, Mr. Joshua Shekhe. Lordship, we have complied and settled the matter in this case on our part. Now it's for the department to comply.
No,
I
but
believe-
the
I believe,
communication which you have
yes,
sent
yes,
to
we have
the concerned
intimated the
department,
department.
you have to produce it and give a copy to the petitioner also. Learned counsel for the petitioner, Mr. Wati Jamir is present. So, learned counsel, Mr. Such and Such, appearing on behalf of respondent number 3, submits that 3, isn't it? 3 / Accountant General Nagaland submits that the matter has been the pension matter has been settled from their end, and the same has been communicated to the which department?
RD and also
To the Rural Development Department for further necessary steps. So, learned counsel, Ms. Such and Such, appearing for
Respondent 1 and 2, on behalf of
respondent
lead
1
counsel.
and 2. 1 and 2 is the RD.
Yes, Your
1
Lordship.
and 2 also submits that they have received.
We are yet to
They are
receive.
yet to receive the communication from the Accountant General, and therefore prays for some more time. So, list after
Ladyship, 2 weeks, Your Ladyship.
just after 2 weeks in order to enable the respondents to show their compliance before this court.
Much obliged, Your Ladyship.
May I please, Lordship? Lordship, I beg to mention item number 5, Lordship. Lordship, we have filed our rejoinder affidavit, and probably the pleadings are complete, Lordship. Matter may be fixed for hearing in the month of September, if possible, Lordship.
Admission hearing.
But may not reach. When do you want?
25th September, if possible, Lordship.
September.
Is too far.
Yes, Lordship.
Let it be in August, sometime in August.
Yes.
Okay, Lordship, then
Maybe 20th August.
20.
Learned counsel for
Okay,
the
okay, Lordship.
Learned counsel
20.
for the petitioner, Mr. MJ Gogoi is present. Stop. He submits that the pleadings are complete and the matter may be listed for hearing. Stop. Learned senior government advocate, Ms. S. Mary is present, as well as
Here I'm
Mr.
appearing as PP.
Okay, yes, BP is present, as well as Mr. Nisuka Chishi for respondent number 2. So, list for admission hearing on 28.
Obliged.
Obliged.
Please, Your Ladyship. Your Ladyship, I beg to mention item number 4 on behalf of the additional AG, V. Shokri.
Yes.
Your Ladyship, an additional affidavit has been sought for in this matter. 2 weeks' time may be granted.
Additional affidavit.
Yes, ma'am.
This is a COP, so she is appearing for respondent
1, 2, 3, and 5, Your Ladyship.
1, 2, 3, and 5. And she wishes to file an additional affidavit.
Your Lordship, the court has sought for an additional affidavit in the last order.
Okay. On the last occasion.
Yes, Your Ladyship.
Learned, your government advocate?
Yes, Your
Learned
Ladyship.
government advocate, Mr. Such and Such, makes a mention on behalf of Ms. V. Shukri, who is appearing for the respondents number 1, 2, 3, and 5. So he submits that this court had directed the respondents 1, 2, 3, and 5 to file an additional affidavit, and he therefore prays for 2 weeks.
2 weeks' time,
2
Your
weeks'
Ladyship.
time to file the same. So, learned counsel for the petitioner, Ms. Manu Senor is present. So, list after 2 weeks as prayed for. Yes.
Much obliged.
May it please, Your Lordship, I beg to mention hearing item number 26. Here, The counsel for the petitioner was allowed to file an application for implement of the informant in the third FIR. However, the petitioner is out of station, so we could not obtain his signature. So kindly grant 3 weeks more time.
To implement who?
Item number 26.
No, for implement of
Implement of the informant in the third FIR.
informant. Oh, okay. Learned counsel for the petitioner, Ms. Mendocino, submits that the petitioners were given, were directed to implement the informant in the third FIR as a necessary party in the present petition. So, however, the petitioner is out of station.
Yes.
Is out of station, and they could not get the signature of the petitioner in the application. Therefore, she prays for how much time?
2 weeks
3 weeks time to file the same. So, Planet PP, Mr. K. Angami is present, as well as Mr. Chuba Nangam for
Respondent five and six,
number
Lord.
5 and 6. So, please after 3 weeks as prayed for. Yes.
Obliged, Lord.
I also beg to mention item number 28. hearing. The leading counsel is indisposed. I pray that this matter may be listed after 3 weeks.
Learned counsel, Ms. Mendocino, submitting on behalf of the leading counsel, submits that the leading counsel is indisposed and accordingly prays for listing the matter after 3 weeks. Stop. List after 3 weeks as prayed for.
Your Ladyship, I'd like to mention
Yes.
item number 27 for hearing.
27.
27.
Yes.
In this case, I'm representing the
Yes.
sole respondent.
Uh,
If this matter may be taken up after 3 weeks.
who's for the petitioner?
Lordship, I'm for the petitioner 2 and 3, Lord.
Any objection?
No.
3 weeks, no?
Lordship.
Learned counsel for the petitioner, Mr. Chupad Nankam is present. So, learned counsel, Mr. Moa Jimir, appearing for the respondent's number.
Sole respondent.
Okay, the sole respondent prays for listing the matter after 3 weeks. So, list after 3 weeks as prayed for. Yes.
Obliged, Lord.
Also in item number 15, Lordship.
1-5.
1.
Yes.
This case, Lordship,
It should
your
be
Ladyship
listed.
was also a member of the association.
Yes. 15, huh? List this matter before any other bench without me, okay? Why long kamar put the name? Yes.
Obliged.
May I please, Your Lordship, I will please to mention item number 21. 21. Your Lordship, here I have instruction to appear for respondent number 2 to 5, Your Lordship. Your Lordship, so 4 weeks may be granted, Your Lordship, for obtaining instructions.
2 to 5.
Yes, Your Lordship.
Okay, learned counsel for the none appears for the petitioner when the matter is called. So, learned counsel Ms. Livika, a government advocate Ms. Livika, submits that she has received instructions to appear on behalf of respondents number 2 to 5 and prays for
4 weeks.
4 weeks time to file the Vakalatnama and to get instructions. So, please after 4 weeks as prayed for. Yes.
Yes, Lordship. Lordship, I beg to mention item number 18.
18. Yes.
Kindly allow me to include a new incumbent, respondent number 4, who's been transferred. So kindly
4.
allow. Yes, my Lord.
Respond for. Learned counsel Mr. A. Sophie is present. Learned counsel submits that the respondent number 4 has been transferred out and accordingly he would like to file an improvement application for the new incumbent. So, Learned counsel Ms. S. Mary appears for respondent 2, Mr. N. Angami for respondent 1 and Mr. K. Angami for respondent 4. So, the prayer of the petitioner is allowed. List. Main case we can list after 4 weeks. List after 4 weeks, and then in the meantime you file your IA.
Fine, my Lord. Obliged, my Lord.
Yes.
May I please, Ladyship?
Yes.
Ladyship, I beg to mention item number 17. I'm for respondent number 4. Here, I've filed affidavit with regard to the status taken by the respondent department. The process is under the process for compliance with the direction passed by this honorable court. So
Item
now,
7.
item 17.
Oh, item 17.
Yes.
Okay.
So the matter
Yes,
may-
yes. So what did you say?
I filed my affidavit stating the status of the compliance. Now the matter is being compiled by the department to be placed before MRC.
Regularization.
Yes. So sometime maybe
None
after 4 weeks.
appears for the petitioner when the matter is called. Mr. K. Angami, learned counsel appearing for respondent number 4, submits that the process of regularization of the petitioner has already started and the matter is now pending before the Manpower Rationalization Committee, after which...
Not yet. It's being compiled to be sent to
it is being compiled to be sent to the Manpower Rationalization Committee, and thereafter it will be put up to the cabinet for approval. So, accordingly, he prays that the matter may be listed
after 4 weeks.
After 4 weeks. List after 4 weeks. Yes.
May I please, Lordship? Lordship, I beg to mention item number 7 on behalf of additional AG Im Tim Song. Item 7.
7.
Lordship. Lordship, the state respondent is yet to receive instruction. So, Lordship, please.
But it is a fixed matter actually.
Lordship, last opportunity was
Last
last
opportunity.
opportunity to the state respondent to
But state is always asking for last final. Respondent 4. This is 4. Wait. Okay, and what about the private respondents? Already filed?
No, sir. I'll be submitting on the time of hearing.
Okay. Learned counsel for the petitioner, Ms. Manisun is present. Stop. Learned government advocate, Mr. V. Jimomi, makes a prayer on behalf of Mr. Im Tim Song, additional AG, to list the matter after 3 weeks as the state is yet to file the affidavit in opposition. Stop. The learned counsel for the petitioner submits that on the last occasion, a final opportunity had been given to the state respondents. Stop. However, in view of the fact that the additional AG, he has received instruction?
No.
Not yet. Additional AG is yet to receive the instructions. So as a final opportunity, the state respondents are given another 4 weeks. Okay, so please after 4 weeks, in order to enable the state respondents to file the affidavit in opposition. Yes.
May I please, Your Lordship? I beg to mention item number 24. My senior is indisposed, so kindly fix the matter after 2 weeks.
Item 24. Okay. Learned counsel, Mr. Such and Such, mentioning on behalf of the leading counsel, who? Zimomi, prays for listing the matter after
2 weeks.
2 weeks.
Lordship, for respondent number 3.
Learned counsel, Ms. Such and Such is present for respondent number 3. List after 2 weeks as grateful. Yes. That is item 24.
Yes.
My please, my lord. Your Lordship, I beg to mention item 20. Here I receive instruction to appear for respondent number 1. Your Lordship, I am filing my vakalat nama as well as affidavit in opposition if necessary. Therefore, I pray that 3 weeks time may be given.
3 weeks.
Yes, Your Lordship.
Learned counsel for the appellants, Mr. Z. Kohima is present. So Ms. Such and Such submits that she has received instructions to appear on behalf of respondent number 1 and prays for 3 weeks time to receive instructions and to file an affidavit in opposition if so advised. Stop. List after 3 weeks.
Your Lordship, can it be listed after 2 weeks because there are some other respondents also. So if just for their appearance and all those.
Respondent 1 is the claimant.
Claimant, yes.
But she has to get the. Have you filed your vakalat nama?
Not yet, Your
Not yet.
Lordship.
So just after 2 weeks.
Okay. 2 weeks then. After 2 weeks.
Much obliged.
This is Ladyship. Ladyship, I beg to mention item 25. Ladyship, this matter has come up for hearing. However, we have been informed by the registry that from the bench that paper books are ready. However, on 2 occasions we have intimated the authority concerned to make the payments. However, the authority concerned is yet to make the payment. I'm on behalf of the appellant.
The paper book costs.
Yes.
Unless you pay that, you will not get the paper book.
Yes, lady. We've intermediate done on 2 occasions. The last being on 26/6/2026. It was right before the vacation. However, we haven't received any communication from their end. If
You
the matter
talk
can-
to them personally and ask them, because it is their appeal.
Yes, lady.
If they don't want their appeal to proceed, it's fine. But if they want their appeal to proceed, they have to pay.
If appropriate direction may be passed, and then can communicate it.
No, they should know this, all these things. Learned counsel for the appellant, Mr. Nongosa, is present. Stop. Learned counsel submits that the paper book has already been prepared by the registry. However, the appellants are still are yet to pay the paper book costs, and because of which the registry is not allowing the parties to get a copy of the paper book. Stop. Learned counsel submits that he has already informed the appellants on 2 occasions, but the costs are yet to be deposited. Stop. The Union of India is the appellant herein, and unless the appellant pays the costs for the paper book, this appeal will not proceed. And accordingly, the appellant Union of India is directed to deposit the paper book at the paper book costs at the earliest before the registry. So list after
4 weeks.
4 weeks for hearing. Okay. So,
I'd like to mention item 22.
22 is already mentioned, I think, isn't it? 22. Oh no. Yes, 22.
I'm yet to receive instructions.
Item
So may I
22.
pray that 4 weeks' time may be granted.
Learned
Lordship,
counsel.
may this be the last chance, Lordship?
No. The matter was taken up only in the month of April this year.
Yes, this is 26 matter. Learned
This is
counsel.
the second. Too harsh.
Learned counsel for the petitioner, Mr. Sansar is present. So, Learned Additional Advocate General, Mr. L.T. Sanctum, prays for
4 weeks'
4
time.
weeks' time to receive
Lordship, in
instructions.
both the IA and the writ petition, there is an interim order. Lord.
Wait. The IA is for what?
Stay, Lordship.
Stay. And, okay, 4 weeks' time to receive instructions and to file affidavit in the possession. No? So, prayers allowed, please, after 4 weeks. The interim order passed in IA 71 of 2026 and WPC, which WPC? 35 of 2026 shall continue till the next date of listing. Okay.
Much more.
Lordship, I'd like to mention item number 9. Here, the Transport Department, newly employed party, you want to file the affidavit. So 1 week time will be granted. After one
Which department? Transport.
Yes. 60% of the damage was allocated to the transport.
Your Lordship, in fact, I object to this because on the last occasion, Lordship, last opportunity was given by this court, seeing the gravity of the case, Lordship, the seriousness of the case. Although we're just demanding, the petitioner here is just demanding, praying for a simple direction, Lordship. Now I'm also very confused now because here, my learned friend is representing even the district administration, Lordship, who has headed in compiling an assessment report, Lordship. And they have, as per their findings,
This is what? Land compensation?
damage compensation,
Oh,
Lordship.
damage compensation.
Because the petitioner herein is displaced, Lordship, and for no fault of hers, Lordship. And the assessment is done from 22nd to 25th of November 2024, Lordship. More than one year and 8 months have passed.
And what about the rest, 60%?
In brief,
60% is yet to be paid, Lordship.
Lordship, in brief,
Now,
as per the district committee, they have operationed the damage and transport department, NSD, it was fixed at 60%, NHATCL 40%. So NHATCL they have already paid. And now petitioner is fighting for the 60%
Lordship,
against the
yes.
transport department.
Okay.
So I will be allowed to file the affidavit and chapter will proceed.
No, but you have intention of paying, isn't it?
There
Or
are some
you have
dispute.
no intention.
I have several time sitting, then they said that they are not satisfied with that. So
No, Lordship, if
I've
that
been
is the
allowed to
case,
file.
what were they doing for the last more than 1
Yes,
year, Lordship?
yes.
Now the petitioner is suffering, Lordship.
This will be the last chance if we cannot file affidavit.
Lordship, in fact, Lordship, if you allow me to
the
kindly.
problem is, the calculation was already made, and
It is,
I'm
Lordship.
sure you were also there when the assessment
no.
was done.
That the condition of the transport department, they were totally ignorant of the assessment done, and the committee has 2 times they have visited and the assessment. It was completed on the second round of assessment.
But if you were aggrieved by that,
Yes.
there were remedies available
Yes,
to
yes,
you.
there is a remedies there.
But they did not take the remedy. They did not avail the remedy.
Yes, and the transport
And now
was.
this petition is already
yes,
filed.
and transport department was recently implemented as a respondent. Initially, the transport department was not a party.
Lordship, they were
Recently-
only made a
recently
party,
means
Lordship.
This year, I think this year. Or,
Yes, this petition was filed this year, Lordship. Now, during the course of hearing, in fact, respondent number
Okay,
4
let them
is the
sort it
general
out.
manager,
Let them
Lordship.
sort it out. We'll
Yes.
see on the next day.
Also, Lordship,
Yes,
kindly
yes.
allow me to refer the last order, Lordship. Here, wherein this court has clearly stated that, Lordship, if affidavit is not filed by 20th of July 2026, this court shall dispose of the instant proceedings on the basis of the materials available in the court. Now, Lordship, this is the order pass, but then they are not very actually serious about the case also, Lordship. In fact, they could have raised objection if they are aggrieved.
Amen.
And also, Lordship,
Amen. Just show me the last order. Last order. Item 9. Learned counsel for the petitioner, Ms. Nitya Koza is present. Stop. Learned counsel for respondent number 2, Mr. Moa Jamir is present. Stop. Learned additional advocate general appearing for the respondent number. Respondent number.
that's the respondent. Three to 6.
3 to 6 prays for some more time to file the affidavit in opposition as the three to six.
7 is a transport department. Lordship.
No, 4 is general manager NST.
Lordship, yes. And 7 is, Lordship, if you, 7 is the
okay,
Commissioner
there-
Secretary,
7
Lordship.
is a Commissioner Secretary Transport.
Achha, there is an amended petition.
Yes,
Yes.
Lordship, we have filed the taken steps also already, Lordship. In fact, it's already started reflecting in the CIS, Lordship, in the orders also.
What did I say? Learned additional submits that the respondent number 7, I, Commissioner and Secretary of the Transport Department, Nagaland, has been recently implemented as a party in this present writ petition, and therefore further instructions need to be sought from the respondent number 7. So, para. On order dated 5/6, by order dated 5/6/2026, this court had observed that if affidavit is not filed by the state respondents, on or before 27/2026, this court shall dispose of the instant proceedings on the basis of the materials available on record. Stop. Mr. Moa Jamir, the learned counsel appearing on behalf of respondent number 2, had also submitted on 5/6/2026 that the respondent 2, that means they have already paid, na?
Yes, Lord.
Respondent number 2 has already paid their share of the compensation amount, i.e. 40%, and therefore they ought not to have been made a party in the present writ petition. Stop. In view of the fact that the respondent number 7 has been impleted recently and the learned additional AG needs to receive further instructions, please the matter after 2 weeks, okay? After 2 weeks, on which date the matter, in which date an endeavor shall be made to dispose of the matter.
Obliged.
For admission, item number 1, 2, and 3.
May it please, my Lord. Lordship,
Yes, yes.
I am told the CPI Council, Standing Council, will be back shortly. He has come out to attend some lectures call.
Okay, you start, it's okay.
Lordship, in order to refresh the memory of this Honorable Court,
Not refresh, this is the first time.
my Lord, but
You have to start from the beginning.
my Lord, yes, but this is a case, I believe, the members of both the bar as well as the bench, how it started is well aware of, and the genesis, my Lord, is the order dated 2 May 2018, passed by the Honorable Principal Sit Gauhati High Court in PIL Sumuto 5 of 2017. My Lord, here a direction was given to the CPI to conduct.
Have you annexed?
I have annexed the letter written by the Registrar General Gauhati High Court to the Director CPI, based on the letter, based on the order passed by the Principal Seat. The same is at annexure page 156, annexure 6.
Page?
That copy is at 156.
Page 100 and?
156.
156.
The untyped copy is at 154.
This was letter dated
3/5/2018.
3/5/2018. Yes.
I may be permitted to read from the typed copy. From Mr. So-and-so, Registrar General Gauhati High Court Gauhati, to the Director CPI, plot number so-and-so, so-and-so. Dated Gauhati, the 3rd May 2018. Reference, order dated 2/5/2018, passed by the Honorable Gauhati High Court in PRL Sumuto number 5 of 2017. Sir, with reference to the above, I am directed to forward herewith a true copy of the order dated 2/5/2018, passed by the Honorable Gauhati High Court in PRL Sumuto number so-and-so, which is self-explanatory. The Honorable High Court, while order under reference has been inter alia, pleased to direct as follows. We accordingly direct the CPI to conduct a preliminary inquiry into the allegations of misappropriation of public money vis-a-vis the snail pace of construction work of the new High Court complex at Kohima, Nagaland, and submit a report within 3 months to the Registrar General of this High Court. Needless to say that if the CPI is of the view that there is any material to support the allegations, it will take action as per law by registering first information report, etc., and the state government shall fully cooperate with the investigation. This direction is in conformity with the direction given by the Supreme Court in Noida Entrepreneurs Association versus Noida 2011 6 SCC 508. We also direct the Director CBI to depute an officer immediately to collect all the relevant reports from the government of Nagaland pertaining to this public interest litigation. Now, after this, prior to filing of the FIR, preliminary inquiry was conducted. The preliminary inquiry is narrated, my lord, in the charge sheet filed by the CBI. If my lord will kindly go to page 90, this is important. Because the order that I am challenging, some observations, some conclusions have been drawn based on this preliminary report. At page 90, paragraphs 16.10, 16.11, 16.12 and 16.13. This pertains to preliminary inquiry. That is, yes,
16.10,
11, 12 and 13.
11.
Yes, prior to filing of the FIR. And from 16.14, it is after filing of the FIR. So I may be permitted to read 16.10, 11, 12 and 13 at this
Prior
stage.
to FIR. 16.10, 16.10.
FIR was filed only in 2019, and whereas these reports were submitted in 2018. So
Yes. Please read.
the said engineer Satvir Singh Dalal, AE, and engineer so-and-so, JE of CPWD Kohima submitted report, which was forwarded by EE, CPWD Gauhati, right later dated 22/10/2018. As per the report submitted by the said two engineers of CPWD under the heading Internal Road Connectivity, it is mentioned that the black top road and Paka footpath paved with checker tiles from main highway NH61, that is Oka Road, to the main building of High Court is existent, though under wear and tear. The total length of the road is 1.70 kilometers, with an average width of 6.so meters, which was completed years back. The sites of yet to be constructed residences and other infrastructures are not connected by Paka blacktop roads, and instead only metal road without blacktopping have been constructed. This observation is important, the last line. The sites of yet to be constructed residences and other infrastructures are not connected by Paka blacktop roads, and instead only metal road without blacktopping have been constructed. I'll come back to this later. 16.11. Hence, based on the said report of CPWD engineers, the payment of excess amount was worked out at rupees 1 crore 30 lakh so and so, due to shortage in land by 300 meters for so and so, for rupees 72 lakhs 14,205. Length found as per the report is 1,700 meter against 2,000 meter as per work order, and 2, due to shortage of width by 1 meter for rupees 58 lakhs 50,070 rupees. Width found as per the report is 6 meter against width of 7 meter as per work order. 16.12. In the said report submitted by the engineers of CPWD and in the aforesaid memorandum dated 26/9/2018, no details are mentioned as to how the length and width of the road were measured, and moreover, the inspection/measurement was done in the absence of the accused contractor. This is the own report of the CBI. 16.13. Whereas during investigation, it is informed by the aforesaid two engineers of CPWD that the length of the road was measured with the help of millimeter of vehicle, and the width was measured randomly in 3 to 4 places only by measurement tape. Hence, the accuracy of the length and width of the road, as mentioned in the report of the CPWD engineers, is doubtful based on the nature of the measurement. Now, my lord, based on this preliminary report, FIR was filed, which I have annexed. At Annexure 7, it starts from page 158. Here there are 6 allegations.
You have not annexed the preliminary report. That is not there
It is not with
on
me.
record.
I only have the FIR. Whatever I have with me, I have annexed.
Okay, so basing on this, FIR was filed.
Yes.
Where is the FIR?
FIR starts from page 158, Annexure 7. Here,
Seventeen 6/2019.
yes, my lord. Now, a series of work orders were issued for construction of the main building, my lord, for construction of retaining walls, and I am the contractor for construction of road and footpath. Now, as my lord can see at page 164, it's a lengthy FIR. I have given type copy as well. 164. The allegation A, 164. It is in bold and underlined.
Yes.
A, construction of main new High Court building. This allegation, it does not relate to me. This was executed by somebody else. Or we can say the main contractor. Because this is the main structure under the series of work orders that have been issued.
This is the main court building.
Yes, yes. Now B, construction of retaining wall in the new High Court complex. C, construction of additional work for providing retaining wall in the High Court complex. D, construction of retaining wall and site leveling at new High Court complex. E, works of construction of 500 kVA 33/so substation HT and LD line at new High Court complex, Kohima. All these work orders, it does not relate to me. These work orders were not issued to me. The allegation against me is only with regard to F. Construction of blacktop road and Paka footpath with checkered tiles. From main highway NH61 Waka Road to the main building of High Court. I may be permitted to read the allegation against me in the FIR. Inspection measurement of this work by engineers of CPW revealed shortage in length by 300 meters and shortages in width by 1 meter. The value of these shortages in length and width of the road as calculated by the engineers of CPW comes to rupees 1,30,54,275, which is an excess amount paid to the contractor Sri so and so MT of MS Hexat Syndicate as a result of criminal conspiracy with Sri so and so, that is EE. He has already retired by the time the instant charge sheet was filed. Sri so and so EE retired, Sri so and so EE, Sri so and so STO, and Sri so and so STO, and Sri so and so JE, all of Nagaland PWD, and thereby caused wrongful loss to the government of Nagaland and corresponding wrongful gain to themselves. Now, the most important document here is the work order. The work order was issued way back in 2008. I have annexed the same at Annexure 1, page 55. The original copy is also quite readable. The type copy is at page 57 to 58. Page 55, my lord, Annexure 1.
Yes.
Here, the date is important. 2nd January 2018, no, 2008. The date is important because, my lord, the inquiry or the inspection was conducted in 2018. That is almost a decade after construction of the road by the present petitioners, by the contractors. So naturally,
Conducted in 2018.
yes, the paragraph that I have read from page 90, there it is clearly reflected the date. Submitted report which was forwarded by EE CPWD Gauhati, white letter dated 22/10/2018, page 90, paragraph 16.10.
Yes.
22/10/2018. And the work order is issued in 2nd January 2008.
This one, the
Yes.
total length of the road is 1.70 kilometers with an
Yes.
average width which was completed years back.
Yes, yes. Three things are important here in this work order at page 55. One is the work order amount, two is the date, three is the length. But I'll come to the length portion later on, but the date, and secondly, the amount is at top of the page. Approx value of work 581.85 lakhs, rupees 5 crores, 81 lakhs, so and so, so and so. Figures and words both are given very clearly.
$581.85.
Now, my lord, the fact that the work order is valued at that particular amount is also well accepted, acknowledged by the CPI in the charge sheet at page 87, paragraph 16.8. This is important because here the allegation is that I have received excess payment. The main allegation is that. So whether I have received excess payment or not, it will depend on the work order amount and the amount that I have received. So at page 87, paragraph 16.8, I may be permitted to read 16.8, page 87.
Yes.
Investigation revealed that the construction of this road was given to the NPWD RNP by the user department, that is the Department of Justice and Law, and NPWD RNP in turn. After tendering, had valued the work to the accused contractor so and so, proprietor of MS so and so, right work order number so and so, dated 1/2/2008, issued by Dr. Engineer so and so, Chief Engineer RNP, for total value of rupees 5,81,85,820. Now the third thing, with regard to the length, my work, my lord, was to construct the road from the highway and till the High Court building, and as well as to encircle the new High Court building. Because encircling is essential because there is entrance both at the front and at the back of the building. Yes. The honorable judges and the members of the registry, I believe, some members, I believe, were to enter from the
back.
Yes, from the back, and the public and the lawyers are to enter from the front. So this encircling was essential. And along with that, the footpath also, where there is no partition. Now, we constructed road till at that relevant point of time, till the area where the new High Court building was to begin its construction. And we discussed that it was decided that after the new High Court building is completed, the encircling portion shall be constructed. Because at that time, had we constructed the encircling portion, then building equipments will be dumped, huge building equipments, huge machineries for construction, and naturally it will result in loss to the state exchequer. Because it will be unusable. So, with that in mind, we stopped the work, and about 300 meters, 347 meters to be exact. Were left to be constructed when the High Court building is completed. The structural works, that is, internal electrification, carpentry works, it can go on. Laying of tiles, flooring, and all this. But after the construction of the main structural work, it was decided that only after that the encircling portion shall be executed. Now, we executed the work for 1,663 meters.
163.
1,663 meters. And 347 was to be executed after the construction of the structural works of the new High Court building is completed. Now, for the executed work, my lord, we have.
Have you stated that anywhere?
Yes, yes.
That you
Yeah, and then that is
you
also
had executed only this much and this much was left.
yes, yes. It is not disputed.
No, but still in your
Yes,
pleadings, in your
in
pleadings.
page 93 of the CPI charge sheet, in para 16.5.
$16 point?
15, 16.15.
16.15.
Yes, page 93, 16.15. Page 93. The valuation report so and so was accordingly submitted under the joint signatures of all the aforesaid three engineers. However, in brief, the joint physical measurement, which was done extensively, established the shortage in length of the road by 347 meters as against 2,010 meters as per the measurement book. So there is a shortage of 347 meters. Now, from 2010, if we deduct 347, it arrives at 1,663. So we have constructed that. Now, for that constructed portion of the road as well as the footpath, the footpath is also short by 238 meters. The next paragraph, 16.16.
Detail measurement.
Yes. Now, as my lord can observe, the length of the shortage in length of the road is 347 meters, whereas the length in shortage of the footpath is only 238 meters. It is because in the main High Court building we have to leave spaces for where there is partition between the roads and for pedestrians
But rejected as.
to access the main High Court building. There are 3 or 4 gates, so which is why there is a difference of about 90 to 100 meters.
And this length which was left 347 meters.
Yes.
That is for the encircling road.
Yes, yes, yes. We have already completed this, but later on I'll come to that part. Now, for the work that we have already executed, 3 running appeals were issued. A chart of that is also given in my petition at paragraph 3 at page. It begins from page 3. The table is at page 4.
Three running bills.
Yes.
Yes. So in total you were paid 4 crore 50 lakhs.
52 lakhs 99,286. Out of 5.5 crore 81 lakh something. The first RAP is worth 40 lakhs, the second is worth 3 lakhs 38,000, and the third, no, another, the second running account bill was issued in 2 checks. All this, my lord, is well documented by the CPI at paragraph 16.24 of their charge sheet, which is at page 99. The type copy is at page 100. Page 99.
16.24.
24. Yes, my lord.
Yes.
I may be permitted to read. This paragraph, my lord, I have converted into a chart in my petition, which I have already taken my lord to. 16.24. Investigation revealed that the first running account bill of rupees 1 crore 44 lakhs so and corresponding false interest in MPs were measured by the accused so and so, which were countersigned and passed by for payment by accused so and so. The second RAP and corresponding false entries in MPs were measured by the accused engineer so and so, which was countersigned and passed by the for payment by accused so and so. Whereas the third running account bill of rupees so and so were also prepared by engineer so and so, but countersigned by engineer so and passed for payment by accused engineer so accused number 5, executive engineer. Now at paras 16.26, 16.27, and 16.28, I believe this will be more helpful because here they have taken the calculation in a technical manner. In 16.26, investigation revealed that an amount of rupees 40 lakhs white check number so and so dated 19 to 2008 against so and so, amount of rupees so and so, after necessary deductions and amount withheld had been received by one of the accused partners so and so by signing the said first running account bill, and the said check amount had also been encashed by him from the bank. 16.27. Whereas an amount of rupees 3,38,49,000 via check number so and so, dated 27th July 2010, and another amount of rupees so and so, 14,57,900, check number so and so, dated 9/8/2010 against second running account bill of rupees so and so has been received by another accused partner, Sri so and so, accused number 16, by signing in the said second running account bill, and the said check amount of rupees 3,38,49,000 had also been encashed by him from the bank, whereas the check amount of rupees 14,57,900 had been credited to his account number so and so. 16.28. Against third running account bill of rupees 4,81,570. This figure is important because this shows the total, this is the calculation of the total amount of work that we have executed thus far. An amount of rupees 50 lakhs white check so and so, and another amount of rupees 9,24,531 white check number so and so, dated 16/6/2011, had been received by the said partner Sri so and so by signing in the third running account bill, and both these checks amount had also been encashed by him from the bank. Now, the fact that I have received only 4,52 lakh something out of 5,51 lakh something is also well acknowledged by the CPI in their counter affidavit. Not only in their charge sheet, but in the counter affidavit also at page 9. In their reply to my paragraph 3.
Wait 1 minute. Just push the counter affidavit of the
CPI.
Counter affidavit of the CPI. Yes. I think this is the trial court records, isn't it? But affidavit in opposition. Affidavit in opposition was filed. Where is it? Maybe in the other two petitions.
Yeah, after the rejection for numbering of the case number in the earlier counter affidavit that we have filed, on the basis of the marking made in the petition, it was numbered as 11, 12, and 13. That was being detected by the registry, and the numbering was being changed 10, 11, 12. Thereafter, it was filed.
When was it filed? The corrected one?
The corrected one, it was filed last 2 months back.
Oh.
Before the matter.
Then it should be there. Okay, anyway. Affidavit in opposition, you just give me the relevant para and the page.
I don't know. Contents are also, but just because of the numbering, it was rejected once.
My lord can refer to one of the. This is criminal petition 12. So they are all co-accused. So, in my reply to paragraph 3, my lord, in that.
See, there is a page numbering and the difference are there. So, since if my learned friend is going for criminal revision petition 10, then
Now we are on 10.
yeah. So if he gives 12, the page numbering in the other cases are a little bit
A
different.
little bit different.
So to assist the court, I can provide my copy as of
Okay,
now.
okay.
Because the page number will be different, so the contents will be a little bit different from the other cases.
Page 9. My lord.
Page 9, para 3.
Yes, my lord. Reply to my paragraph 3. The very first sentence. On the other hand, the total payment of rupees 4 crore 52 lakhs 99,286 was obtained by the accused contractor, petitioner, and his partnership firms. So, there is no dispute to the fact that I have received only the amount mentioned.
So according to you, this 4 crore 52 something
Yes.
is for the work which you had already executed.
Yes.
The road
Yes.
coming from highway till the High Court site.
Yes. Now, the checks that I have obtained, I have also annexed them at annexures 3A to 3D at pages 124
Page 124 is
Yes.
the, no, 125.
Yes. These are all part of the same exhibit.
4 checks.
Yes, 4 checks. Whatever I have received by way of check, I have placed on the record of this honorable court.
Yes.
Now, my lord, after the charge sheet was filed, no, after the FIR was filed, more thorough inquiry and investigation was conducted. And in page 93, at paragraph 16.16, this is very important. In order to show that there is no allegation of substandard work being constructed by me, the CBI in their entire case in the charge sheet file against me, there is no allegation of substandard work being executed by me. However, in the impugn order, when charges were framed against me, despite no such submissions being made by the CPI, because all submissions were made based on the charge sheet only. There is specific allegation against me that there is substandard work which was executed by me, and that no reasons were given whatsoever for arriving at such a conclusion. But that I'll come later on. However, at 16.16, detailed measurement was also done in respect of width of the road and other items which drain footpath with checkered tiles, culverts, press wall and retaining wall. This is important. However, no discrepancy was found in width and other said items except shortage by 238 meters in length in respect of footpath with checkered tiles and the excess amount of rupees so and so paid to the contractor against this shortage has been worked out at rupees 3,78,777 by the CPWD engineers in their aforesaid report. Now, in paragraph 16. This is with regard to footpath. In 16.15, it speaks about
16.15.
yes. It speaks about the road. The evaluation report dated so and so was accordingly submitted under the joint signatures of all the aforesaid 3 engineers of CPWD. However, in brief, the joint physical measurement which was done extensively established the shortage in length of the road by 347 meters as against 2010 meter as per MP, and accordingly the corresponding excess amount paid to the contractor against the said shortage in so and so has been worked out at rupees so and so by the said CPWD engineers. So, except for the shortage in length of 347 meters, I am repeating again and again, with regard to the road and 238 meters with regard to the footpath, there is no allegation. It is clearly reflected that there is no discrepancy in width and other items.
Okay, regarding the road, it is clear.
Yes.
You are saying that your contention is that the road from starting from highway till
to,
the High
yes.
Court has been completed.
Yes.
Only this 347 meters is
For
that encircling
encircling
road.
portion, yes.
Then regarding the
Footpath.
footpath with checkered tiles,
Yes.
what is your submission?
I have constructed from the highway till the portion almost reaching the High Court.
The footpath.
Yes, yes. This stage also
With
it's
checkered
there.
tiles.
Yes. We have come for social work in the new High Court building, the PAR, on 3 or 4 occasions. It is still in existence.
Encircling road. And then
The road may have deteriorated, but the footpath, most of it is in pristine condition.
this is also from the highway
Yes,
to the till the
area where the new High Court begins.
it doesn't reach the main building
No,
area.
no, it doesn't. It doesn't. Only after construction of the new High Court building, we have executed this 238 meters as well.
Okay, so how this 288 meters shortage came, you were saying?
Here also, along with the road, we had to construct a footpath, which is why only after completion of the main High Court building, this footpath was also to be constructed. And here there is a difference of about 90 to 100 meters. It is because we have to leave openings for the judges as well as the lawyers to access the High Court building, which is why the footpath is shorter in length.
Okay.
Now, after the initiation of the investigation in this case, after filing of the FIR, prior to filing of the FIR, we did not meet the engineers. But after filing of the FIR, we had interaction with the CPI investigating team, and we told them that this is the situation, and after the completion of the structural work of the main High Court building, the remaining portions shall be completed by us. But that statement was never recorded by the CBI during investigation. And when no allegation has been made against the principal contractor, against the contractor executing the construction of the main High Court building, despite the CBI fully knowing, I believe, I have strong reason to believe that they know that we are innocent, but they are pretending that we are guilty. Those statements made before them, it was never reflected in anywhere in the charge sheet, anywhere in the reports. And they have blindly stated that excess payment has been received by us. The amount that we have received thus far, at that point of time, that 4.4 crores 52 lakhs something, that was brought over, and the amount, the length of road that we were yet to construct, that portion was calculated, divided into that amount that we have received. And this amount of plenty, 25 lakhs 89,000 for the road and 3 lakhs 78,000 for the footpath has been arrived by the CPI. When, again, one of the important allegations raised in this case is that there is discrepancy in the length entered in the measurement book and the amount that
and the amount which was paid.
Yes, yes. Now, my lord is well aware that measurement book is totally the lookout of the engineers, government engineers. That is accused number 3, 4, 5, 7, and 10. These are all engineers. And there is not even a single allegation made by the CPI against me that I, the contractor, we the contractors, we have made wrongful entry in the MPs. The allegation is all against the government engineers, not against us. In paragraph 16.30, further, CFSL Gauhati has given positive opinion of the signatures of accused engineer so and so in the said RA bills and measurement books. So the measurement book was totally signed by the engineers. In 16.24, at page 99, the entries being made by the engineers is also discussed. Page 99, I have read this paragraph earlier, but I may be permitted to read again. The first paragraph. Investigation revealed that so-and-so bill of so-and-so corresponding false entries in MBs were prepared by the accused engineer, so-and-so, accused number 10. JE, which were countersigned and passed for payment by so-and-so, so-and-so. The second running account bill for so-and-so corresponding false entries in MP were prepared by the accused number 10. Third running account bill and corresponding false entries in MP were also prepared by accused number 10, but countersigned by accused number 8. So I am not responsible at all. We have no privy to it, these measurement books. Now, in page 105, it is clearly reflected that prosecution sanction was denied by the state government against these engineers. In paragraph 16.35, I may be permitted to read. This is important. Because for something that the state government engineers have done, I cannot be prosecuted. For something that my father had done, I cannot be jailed. Criminal liability is not transferable.
Yes.
May I read?
Yes.
However, the state government of Nagaland has declined to issue prosecution sanction orders against the accused engineers of NPWD RNP, namely Engineer so-and-so, accused number 3, Engineer so-and-so, accused number 4, Engineer so-and-so, accused number 5, Engineer so-and-so, accused number 7, Engineer so-and-so, and Engineer so-and-so, accused number 10, as conveyed by the Secretary to the Government of Nagaland, Works and Housing Department, white letter dated 10/12/2021, and hence they are not sent up for trial. So they are not being prosecuted. However, the state government of Nagaland has been requested to review the matter and accord prosecution sanction orders against them also, and hence the learned court may allow the prosecution CPI to file supplementary charge sheet against them as and when their prosecution sanction orders are received from the state government of Nagaland. Now, my lord, this charge sheet was filed on 30 December 2021 at page 108. The date is clearly reflected. The date is important. At page 108,
on
30/12/2021, along with the signature of the Inspector of Police CPI ICP in file, the date is also reflected. In two signatures of two different CPI officials are there, and in both The date is clearly reflected.
Yes.
Now, in order not to come back to this issue again, my lord, it is too late in the day to give prosecution sanction as per the law laid down by the Honorable Supreme Court in Vineet Narayan versus Union of India. The maximum period allowed is 3 months plus 1 if the state is to take the advice of the Advocate General.
My lord, I raise some objection to that extent. Here, just to assist this honorable court, the prosecution sanction which has not been issued to the state government officials, he cannot take shelter on that aspect because the section of law is different in this case. 420 and 120.
420 and 120.
Yes. So, prosecution sanction question does not arise in this case. So, it's a wastage of time. So, let him come to the main point. See the grounds that he have set out in the revision petition. All this are being set out.
My learned friend will get time to...
But when it is not a necessary issue, why we waste?
He's only
I'm only trying to...
about the prosecution
Yes,
sanction.
about the... I am merely trying to point out that...
Okay, just say that the prosecution sanction was not granted.
Yes.
Okay, to the engineers.
Yes. Now,
Okay.
now, in order to prove that, in order to show, satisfy this honorable court that for the false entries in the measurement book or for the wrongful entry in the measurement book, if such allegation is true, even if such allegation is true, I cannot be prosecuted. That's what I want to say.
Okay.
And whether that allegation is true or not can never be proved. Because now it is too late in the day to give prosecution sanction. The law is very clear.
No, but in any case, in the charge sheet also, the allegation about the false entry is not against you.
Yes, yes.
Against you is only the excess payment.
Yes. That is what. This is why I'm trying to show that the allegation against me is groundless.
Yours is only that the allegation is that for
And that the discharge petition
for work
ought to have been allowed.
not done by you, you have been paid excess. That's all.
Yes.
No, this is regarding prosecution sanction.
Yes.
Then
So, my lord, we, after the charge sheet has been filed against us, we filed discharge petition before the learned special judge CPI, Dimapur. The discharge petition was dismissed, and we were directed to face trial before the learned chief judicial magistrate, Dimapur. Because against us there is no allegation of the Prevention of Corruption Act,
PCA
yes,
was not
PCA
there.
is not attracted. So under 120 and 420 of the IBC, we were directed to face trial. And the order was passed in 2024.
One minute, okay. After charge sheet, discharge petition. We have to get the facts straight, no? So,
Yes.
file discharge petition, which was numbered as, so this number.
The discharge petition I have annexed at page 172. Now, In page 171.
which was dismissed on 19/10/2022.
The order was, in fact, there is a problem with the dates, I think. The previous page, 171. This order was passed only on 28th June 2024.
Oh. The
The prayer
order
for
dated
discharge-
19/10/22 was pronounced only
Yes.
on 28/6/24.
Yes, my lord.
On 2022, order was reserved. Order was reserved.
Order was reserved on 19/10/2022.
Yes, and it was pronounced on
24.
Yes.
Now the relevant portion is at page 181.
So we have to take this to 28/6/24 only.
Yes, yes.
And was dismissed on 28/6/24. Yes, then
At page 181 is the relevant portion. Accordingly, in view of the aforesaid, the prayer for discharge of the accused so and so, so and so, so and so fails, and they are to face trial for offences under sections 120B, 420 IPC. Now, here, this discharge petition was jointly filed by 4 accused. Now, the person whose name is reflected first, this is to do with another 2 different allegations. Allegation 2 and 3 in the FIR. And he is not before this honorable court.
which one? Which one?
This page 181.
Huh.
One Mr. Avito Sikosi is mentioned.
Oh, okay.
He is the contractor for the retaining walls.
Mhm.
There is 2 allegations against him, and then he is not before this honorable court.
Okay.
But at least
So only the other 3.
yes, yes, yes. And against the other 3 who were contractors for the construction of the road. Allegation F exists.
Yes. Then against this, you
Yes.
approach the court again.
Yes. Against this, we have approached this honorable court, and this honorable court, speaking through my Lord Justice
22.
Devashish Barua,
So where was that? Where is that?
by Annexure 9, page 199. They approached by way of separate criminal petitions, and it was disposed by a joint common order on 8/4/2025.
2025.
The relevant portion is at page 210. Roman 2, the last paragraph, para 17, Roman 2. Liberty is given to the petitioners in the 3 criminal petitions to file discharge applications at the time of consideration of charge.
My lord, it is very important that he escaped one portion, Roman 1. That is very important. Okay. You should not skip that Roman 1.
I can read it, it's alright.
Yeah.
By this, my
The council has to assist the court in proper perspective.
You start reading from the beginning. 1, 2, 3, 4, everything, the directions.
okay, I'll read the entire paragraph 17. Considering the above and taking into account the respective submissions so made out, it is the opinion of this court that at the time of consideration of charge, the petitioners should be given liberty to file appropriate applications seeking discharge, and upon such applications so filed, the learned trial court, that is the court of the Chief Judicial Magistrate, Dimapur, would be within its power to decide the said application in accordance with law. In that view of the matter, this court disposes of the 3 criminal petitions with the following observations and directions. On the basis of the materials on record and the facts so as written, this court is not inclined to quash the FIR so and so, the CPI report so and so, order dated so and so, passed by the learned Special Judge CBI Dimapur, to the extent that the petitioners would face trial under sections 120B, 420 of the IPC, and all consequential criminal proceedings in connection with CPI case number so and so, under sections 420/120B of the IPC, so far as the petitioners are concerned. Roman 2. Liberty is given to the petitioners in the 3 criminal petitions to file discharge applications at the time of consideration of charge. 3. Upon such application being filed, the learned court of the Chief Judicial Magistrate Dimapur shall duly consider the discharge application on the basis of the materials before the court and pass appropriate orders. 4. The learned Chief Judicial Magistrate Dimapur shall not be influenced by the observations made in the present judgment as well as the order dated 19/10/2022 passed by the learned Special Judge CPI Dimapur while deciding the discharge applications, if so filed. So accordingly,
So no observation was made regarding the merit.
no,
It was sent back.
yes,
Then, after that, let's see the impugn order.
after this, the impugn order is at Annexure 10, page 211. From page 228,
Yes.
the reasons and decision of the learned CJM Dimapur is given.
Starting from page
228. It runs into almost 2 pages. Two pages and something. Shall I read?
Yes.
I have heard the learned counsels for both the parties at considerable length. I have perused the written submissions and written objections supported by the case precedents, including oral case citations placed on report and relied upon by both the parties. The Honorable Supreme Court in Sachan Kumar versus CPI was pleased to lay down the following principles governing discharge and framing of charges. On consideration of the authorities about the scope of Section 227 and 228 of CRPC, the following principles emerge. The judge, while considering the question of framing the charges under Section 227 of the CRPC, has the undoubted power to sieve and weigh the evidence for the limited purpose of finding out whether or not a prima facie case against the accused has been made out. The test to determine prima facie case would depend upon the facts of each case. Whether the materials placed before the court disclose grave suspicion against the accused which has not been properly explained, the court will be fully justified in framing a charge and proceeding with the trial. 3. The court cannot act merely as a post office or the mouthpiece of the prosecution, but has to consider the broad probabilities of the case, the total effect of the evidence and the documents produced before the court, any basic infirmities, etc. However, at this stage, there cannot be a roving inquiry into the pros and cons of the matter and weigh the evidence as if he was conducting a trial. 4. If on the basis of the material on record, the court could form an opinion that the accused might have committed offence, it can frame the charge. Though for conviction, the conclusion is required to be proved beyond reasonable doubt that the accused has committed the offence. At the time of framing of charges, the probative value of materials on record cannot be gone into. But before framing of charge, the court must apply its judicial mind on the materials placed on record and must be satisfied that the commission of offence by the accused was possible. At the stage of sections 227 and 228, the court is required to evaluate the material and documents on record with the view to find out if the facts emerging therefrom taken at their face value discloses the existence of all the ingredients constituting the alleged offence. For this limited purpose, sieve the evidence, as it cannot be expected even at that initial stage to accept all that the prosecution states as gospel truth, even if it is opposed to common sense or the broad probabilities of the case. Command 7. If two views are possible and one of them gives rise to suspicion only as distinguished from grave suspicion, the trial judge will be empowered to discharge the accused, and at this stage he is not to see whether the trial will end in conviction or acquittal. Framing of charge is not a mere empty formality in a criminal trial. The charge is the foundation of the accusation, and every care must be taken to settle that it is not only properly framed at the initial stage of framing of charge. The truth, veracity, and effect of the evidence which the prosecution proposes to accuse are to be considered meticulously. The Honorable Supreme Court of India in State of Maharashtra versus Somnath Thapa, 1996, 4 SCC 659, was pleased to hold if the court were to think that the accused might have committed the offence. it can frame the charge. Though for conviction, the conclusion is required to be that the accused had committed the offense. It was further held that at the stage of framing of charge, the court cannot look into the property value of the materials on record. Now, I have a difficulty with these two paragraphs that I have just read. This deals with framing of charge. Many a times, since there is a thin line between framing of charge and discharge, here we are discussing, here in my application for discharge, the court is discussing about framing of charge. No,
with you, Abuliji, to assist this honorable court.
No, that can always be discussed by the court. Framing
Yes.
of charge, discharge,
When
because
he-
these are all
Interconnected,
connected.
yes.
These are all connected.
So when they are been not allowed, discharge has been rejected,
Let
the
him,
court has.
let
yes.
him conclude. It's okay. Yes.
you'll get a fair chance.
Yes. Yes. Then.
In Union of India versus Prafula Kumar Samal, the Honorable Supreme Court of India observed that while considering the question of framing of charge, the court has the undoubted power to sift and weigh the materials for the limited purpose for finding out whether or not the prima facie case against the accused has been made out. In exercising the power, the court cannot act merely as a post office or the mouthpiece of the prosecution. It was observed further that the test to determine a prima facie case against the accused would naturally depend on the facts of each case, and it is difficult to lay down the rule of universal application. It has been held that where the material placed before the court discloses grave suspicion against the accused, which has not been properly explained, the court will be fully justified in framing the charge and proceeding with the trial. In Kandi Patrasa versus State of West Bengal, so-and-so, the Honorable Supreme Court held that whenever the trial court decides to frame charges, it is not necessary to record reasons or to discuss evidence in detail. In State of Andhra Pradesh versus so-and-so, the Honorable Supreme Court of India held that the stage of framing of charge evidence cannot be gone into meticulously. It was held that it is immaterial whether the case is based on direct or circumstantial evidence, and a charge can be framed if there are materials showing possibility about commission of the offence by accused as against certainty.
Yes.
From the discussion above, it is thus clear that all that is required at the stage of framing of charge is to see whether a prima facie case regarding the commission of certain offences is made out. The question whether the charges will eventually stand proof or not can be determined only after evidence is recorded in the case, that is, after the trial. The real test for determining whether that the charge should be groundless is whether the materials are such that, even if unrebutted, make out no case whatsoever. In other words, if there is strong suspicion and materials showing possibility about commission of the offence by the accused, it is sufficient for the court to frame the charge at this stage. There is no necessity of formulating opinion, if any, about the prospect of conviction. In the present case, upon perusal of the charge sheet and other materials on record, this court finds that there are sufficient grounds for proceeding against the accused persons, namely so-and-so, accused 14, 15, and 16, for commission of offences under section 120B, 420 IPC for substandard works and incomplete construction of blacktop road and Paka footpath paved with checkered tiles from main highway, National Highway 61. Waka Road to the main building of new High Court complex at Mirima, Kohima, specifically in respect of allegation 6 of CPI Charge Sheet 7, 2021, thereby cheating and defrauding the public exchequer and resulting in excess payment to the tune of rupees so-and-so, so-and-so, 29 lakh something. In conspiracy with 6 accused engineers of NPWD, engineer so-and-so, so-and-so, who are not charged since the government of Nagaland has declined to issue prosecution sanction against them. In view of the materials on record and the reasons stated above, the application for discharge filed under section 239 CRBC by the petitioner accused persons, accused 14, 15, and 16, are accordingly rejected. In fact, my lord, the state is, after I have completed the work and completion certificate has also already been issued. I have also annexed the
Oh,
same.
subsequently, you completed the work.
Yes, yes. Which
When?
is why in 2025. Annex year 14, page 240. I have also placed this before the learned CJM Tibapur. The completion certificate was issued on 18th March 2025 by the Chief Engineer, PWD Road and Bridges. And by Annexure 15, I have written to the government for release of the outstanding amount of 191,120 rupees and 50 paisa.
Where is that? Oh, for 241.
Yes, my lord. The type copy is at 242. My lord, it is important to note that in the CPI charge sheet filed against me, there is no allegation that completion certificate was ever issued by the state government, or that I have claimed my bills as if the entire work has been constructed. There is not allegation, zero allegation. Which is why, after I have completed my work, the state owes me 1 crore 91,120 rupees and 50 paisa. So I have written to the state government to release that amount, which they are yet to pay me. And of course, there is breach of contract. It was for 12 months. The CPI can say that there is breach of contract. I may also admit that, but it will attract only civil
The
liability.
first work order was for 12 months.
Yes. In the next one, it is clearly reflected. Now, will a breach of contract automatically attract criminal liability?
No, but the charges against you is only 420 and 120B.
Yes.
Cheating.
Yes. CPI in their charge sheet has stated that, in their affidavit in opposition, they have taken a stand that there is delay in execution of the contract. Now,
No, that cannot be a
yes,
matter to be considered in the criminal case.
but just in order to satisfy this honorable court, I may be allowed to place a single citation.
No,
a breach of,
the court is clear on that.
my lord,
How can breach of contract be
wrongful.
because the agreement must have been signed
Yes,
between
yes,
the
my lord.
department and the contractor.
Yes, my lord. And if
So
the department is aggrieved, they can always
if there was a
file
breach of that,
a suit against me for recovery or take appropriate steps against me for damages
it
and
is for
compensation.
the department to do
Yes, yes. It is for the department to decide, not for the CPI to prosecute me. Now, moving ahead, if I may be permitted to take my lord to Annexure 11, at page 231.
(231).
Yes. There are two allegations made against me. Firstly, two charges. But the observation of the court is important. I may be permitted to read. That you on or about the year 2008-2009, in respect of government work order for construction of blacktop road and Paka footpath paved with checkered tiles from main highway so and so, agreed and implicitly conspired with 6 accused engineers of NPWD RMP by engaging in substandard and incomplete construction of the aforesaid works, specifically in respect of allocation number 6 of CPI charge sheet number so and so, thereby defrauding the public exchequer and resulting in excess payment to the tune of rupees so and so, and that rupees 29,68,345. This is total of the allegation that I have received excess payment with regard to footpath as well as the road, and that you have thereby committed an offence under section 120 PIPC and within my cognizance. Now, there is a charge against me that I have engaged in executing substandard works. In the second allegation also, that same allegation is there. Whereas in the CPI charge sheet, there is no allegation of substandard work, only shortage of length and excess payment being received by me. In the order rejecting my discharge application as well, in the last paragraph, there is allegation for substandard works, whereas no such allegation is leveled against me in the entire CPI charge sheet. Of course, in paragraph 16.10, prior to filing of the FIR, when preliminary inquiry was conducted, 2 CPWD engineers, they made some inquiries, which I have read. There they have stated that the roads have not linked the buildings. Now that is not part of my contract. I can only execute what has been awarded to me. In 16.16, I am repeating again and again, it is clearly stated that there is no discrepancy except in shortage in land. So the question of substandard work being constructed, if such a conclusion has to be arrived at, then the reasons should also have been given why this allegation exists against me. Secondly, why, my lord, I have raised the issue that there is a distinction between order framing charge and an order rejecting or allowing discharge applications. When charges are framed, no reason needs to be given. That is settled law. But when discharge is allowed or rejected, reasons have to be given. And the prima facie evidence why I am not being discharged, that should have been mentioned. He has only discussed why there is no need to give reasons for framing of charge. That is understood. That is not disputed. But this order is not being passed under 228. It is being passed under 239. The first order. The first impugned order. And merely, of course he can say that, but merely on that ground, by saying that no reason needs to be given for framing charges against the accused, An application under 239 cannot be rejected.
Please give me CRPC. Your affidavit was found to be defective. That's why it is not on record.
To be very honest, before to Honorable Court, when I come up for the second time, I've requested the assistant kindly check out whether there is any defect or not. If not, then by now I would like to rectify. So it said that I was informed that if the rectification was complete, then it is okay.
Notary signature missing in pages 1 to 22. Just check.
What has been detected at the earlier point when I've been filing notary signature missing in page 1 to 22. 1 to 22. It's it is below here. If
No,
that is the
pages
notary public.
1 to 22, they say.
Seal is there, but the signature part that was missed out. So that is, if that is the only reason, then we have to.
Signature is not there.
In the last page, the notary has affixed her signature. But in the continuing page 1 to 22, he has just make a seal and put a date.
Signature should have been there.
Yeah, but I was not aware of all this also, but I was on the presumption that everything is okay. When seal signature was done. But if the issue is that from page number 1 to 22 of the pages are missing with the notary signature, then if the court permits, then we can consider this. Otherwise, court should allow me to rectify this by obtaining the signature. Otherwise,
That will again take time because
Yeah.
we have now reached the hearing stage.
yes. So, because of the earlier it was rejected, because for the second time I don't want to take the risk, but so I requested the person who has been manning the section.
Otherwise, it's there in the last page, signature.
Yes, signature in the last page is appended. Only in
Just tell
one.
them to allow, because now we are in the final stage. Yes, so your last point was that there is a difference between section 227
Yes.
and 228.
Yes, yes. Discharge can either be filed under 227 and 239, but the sections, the contents are almost the same. It's just that one is before the magistrate.
But 227 is sessions court.
Yes, yes, my lord. I have filed under 239. I may be permitted to.
239.
Those are three judgments passed by, one passed by the Kerala High Court, one passed by the Karnataka High Court, and the other by the Orissa High Court. The high courts across the country have consistently held that orders under framing of charge and discharge applications are very different. I may be permitted to read A1 and A3. In order to save time, I may not read A2. Para 5, at page 5, my lord. Fasit versus State of Kerala. As far as the legal position regarding the essentials of an order of discharge is well settled. While passing an order of discharge by allowing the same or dismissing the same, the courts must have to state reasons for passing such orders, and an order without recording reasons in the form of cryptic and non-speaking stature would not sustain under the law. In A3, that is Shyam Sundar Akrawala versus State of Odisha. In para 10,
1 minute. Para 10.
yes, my lord.
Yes.
Though it has been held that the court is not required to record reasons for framing charge, but it is the settled position of law that rejection of a discharge petition and framing of charge are not one and the same thing. It is only after an application for discharge is dealt with that the question of framing of charge arises. The language used in section 245 and record his reasons for so doing cannot refer only to a case where the application for discharge is allowed and not when the same is rejected. In a similar case, they have discussed another case.
Yes.
I agree with the judgment produced by the learned CJM, relied on by the learned Chief Judicial Magistrate Dimapur, passed in Sachan Kumar's case. It's just that I only don't agree with the conclusions that he has arrived at after relying on such a beautiful decision. Here, the decision passed in Sachan Kumar clearly speaks about suspicion and grave suspicion. And when two views are equally possible, one giving to suspicion and the other giving to grave suspicion, if there is only suspicion then and no grave suspicion, then the accused can be discharged.
On the same day, charge was framed.
Yes, on the same day.
Yes.
Now at the cost of repetition, my work order is for 5 crore 81 lakh something, whereas I have received only 4 crore 52 lakh something, which the CPI has also not disputed. It is in the charge sheet as well as in the affidavit, it is very clear. And my work was yet to be completed.
So according to you, that remaining work was completed in 2025?
Yes. And that there may be breach of contract, but it cannot attract criminal liability. And that the prosecution against me is an abuse of the process of law. And my lord is well aware that criminal proceeding has far-reaching consequences. In 2015, Volume 3, 123, It has been held the summoning of an accused in a criminal case is a serious matter. And that unmerited prosecution infringes a fundamental right. Because of this case, the state is no longer willing to award new contracts to me. Retailers, hardware wholesalers, and equipment dealers, they are no longer willing to accept my guarantees. In paragraph 17 and 18, my lord, I may be permitted to read. The magistrate, having seen the records and having heard the parties, has come to the conclusion that no offence is made out against the appellant under the provisions of the PC Act, so as to prosecute him. Even according to the High Court, the crux of the matter is the conversation between the complainant and the accused number 1 of so-and-so, so-and-so. That conversation is inaudible and the same is not taken in evidence. Therefore, once the crux goes, the superstructure also falls, lacking in legs. Hence, prosecution becomes futile exercise as the materials available do not show that an offence is made out against the appellant. This part, unfortunately, the High Court missed. A judgment has been reproduced. 28. Summoning of an accused in a criminal case is a serious matter. Criminal law cannot be set into motion as a matter of course. Pepsi Foods Limited and another versus judicial magistrate. The process of the criminal court shall not be permitted to be used as a weapon of harassment. Once it is found that there is no material on record to connect an accused with a crime, there is no meaning in prosecuting him. It would be a sheer waste of public money, time and money to permit such proceedings to continue against such a person. 18. Unmerited and undeserved prosecution is an infringement of the guarantee under Article 21 of the Constitution of India. 60. Article 21 assures every person right to life and personal liberty. The word personal liberty is of the widest amplitude, covering variety of rights which constitute personal liberty of a citizen. Its deprivation shall be only as per procedure prescribed in the Code and the Evidence Act, conformable to the Supreme Law, the Constitution. The ingredients of the offence, Your Honor, is also not satisfied. In Karan Talwar versus State of Tamil Nadu, it has been held as under in paragraph 12 and 14. This is SLB criminal number 10736 of 2022. The judgment and order was delivered on 19th of December 2024.
Para 12.
Yes, para 12. As noted herein above, the sole material available against the appellant is the confession statement of the co-accused. Which accused number 1, which undoubtedly cannot translate into admissible evidence at the stage of trial and against the appellant. When that be the position, how can it be that the prima facie case is made out to make the appellant to stand at trial? There can be no doubt with respect to the position that standing the trial is an ordeal, and therefore in a case where there is no material at all which could be translated into evidence at the stage of trial, it would be miscarriage of justice to make the person concerned to stand the trial. Now, my lord, here as well, the CPI, they may rely on, in the charge sheet, some statements given by the contractor for the main building. But they may also rely on some statements that may have been made before them. But those are not admissible evidence. That is the key word that I would like to deduce from this paragraph. Here also, the confessional statement was recorded before the police, but the court said that no, that is not admissible in evidence. Whereas in the instant case, the statements were made all before the police. In law, CPI is police, which is totally part under the India Evidence Act. My Lord is well aware. It is not admissible. As such, the only important thing that has to be looked into is the work order, the amount that I have received, and the work that I have done. If that is looked into, then I have never claimed excess payment, neither have I received excess payment. Therefore, the prosecution against me, it is unmerited, it is unfounded.
Now, since the engineers have not been granted prosecution sanction, how many accused are left?
Only
for
three of
trial?
us.
Oh, only three?
Yes.
Only these three petitioners?
No, no.
100%.
But
But
that
he
is
is not related to this case.
yes, yes.
But
That is another,
another person
another
is
matter.
related with another country. So
For retaining
So
wall.
as far as this contract work is concerned, only three. Yes, anything else?
For the time being, I would like to stop here and I may be given permission to reply yes.
Okay. Should we start at 2? But another thing is, I have to leave the court premises at 3 dot. I have an appointment.
Then
So,
it will be a part heard.
we can keep it part heard and then continue tomorrow.
Yes, I think that will be best.
We can continue tomorrow.
Yes, Mr. Barua, why are you here?
My friend is from Gauhati and then
He told me, he gave me a caveat today in the morning that, brother, I have got 3 matters. That'll take time, which is
It'll
fine.
take time.
But there is a matter, item number 14. Item number 14. With respect to a criminal petition,
Yes.
yes, the analogous matter with the service matter is coming before your lordship tomorrow. Item number 12. Matter happens to be pertaining to a professor of Nagaland University. Due to some ulterior reasons, a case was registered against this man, against which we came before this court, and this honorable court on the last occasion directed the order that the trial court cannot proceed with the cannot dispose of the trial before the Jenipoto court. And subsequently on the next day, the service matter came up before this honorable court, where the entire action of the Nagaland University from conducting inquiry and terminating me from the job, that has been, notice has been issued and has fixed the matter tomorrow. So that they have to explain, because without the rule, statutory rule, you cannot initiate anything, because that is just surmises. So if my lord is have,
So should we list it together with the WP tomorrow?
my lord, it can be, but your lordship,
But this matter will again.
my lord, that's the
I
reason.
don't know. How long will it take? 1 hour?
Maybe more than that, because I have to make a reference to the decision made by the special court, bringing it and facts, and citation to the.
Day after tomorrow, because my peculiar problem is that, my lord, I've been thrown out of the job. I have been running pillar to post, and your lordship will appreciate that without the statutory rule, I have been thrown out, And on the basis of that, an FIR was lost.
Tomorrow is Friday,
My lord.
so Monday.
Monday, my lord, I won't be available, my lord. If your lordship can, if my friends can accommodate on Monday, please call me.
If the court can continue on Monday, I have no.
Monday.
No, you decide amongst yourselves.
Monday, my brother will accommodate
No,
me.
I have fixed matters in court, one on Monday, as well as on Tuesday and Wednesday as well.
My lord will be available next week. My lord will be available.
You can give a shot tomorrow. We can all give a shot tomorrow.
Well, my lord, I will take a bit time. I will take a bit time. 2 matters, 1 hour. 30 minutes, done.
Okay, item 14, huh?
Yes, my lord.
Yes. Pass over for the day and list along with WP.
WP, huh? 100? 126.
126 of
2026.
2026.
100 of 2026, I think.
Yes.
100 of 2026.
100 of 2026.
Please verify it, okay?
Yeah.
Sorry.
Please certain. Okay. Then this matter
Tomorrow.
pass over. Keep as part heard and list as first item in the admission column. Okay. Please.
If the interim can kindly be extended.
It will definitely extend.
Otherwise, 1 hour we still have 2 to 3
Today.
today.
Yes, but honestly, I cannot be able to finish it in 1 hour. But tomorrow, if we can go for 1 hour hearing,
Then, Your Honor,
tomorrow
my lord.
at least 1.5. Otherwise, 1 hour by that I can finish that. Otherwise, by today I cannot assure that I can finish that. I don't want to go.
Then should we try ours this present matter? I won't take more than half an hour.
No, but the WP is not listed today.
My lord, WPC is not listed.
It is not listed today. So
No.
we cannot do that. We cannot do
Well,
that.
we
Unless
cannot
an order is passed, we cannot do that.
Let it be on tomorrow, my
Tomorrow we have listed. So yours, we can hear for 1 hour and then continue tomorrow.
Yeah,
We can do that. Yes. Okay, at 2 then, huh? Continue.
Oblige, Your Lordship.
May it please your Lordship.
Yes.
Lordship, I'm sorry for my indulgence. Item number 29 and 30 from orders. Lordship, it was listed on Tuesday. In both the cases, Lordship, the appeal has been dismissed. Now this present petitioner with a prayer to withdraw the statutory deposit and then the 50% which was deposited earlier by the appellant in both the cases.
Oh, it was already deposited in the court.
Lordship,
And he had withdrawn or he had not,
Not
withdrawn?
yet.
Not withdrawn.
seeking permission to withdraw, Lordship.
Okay. Where is the?
Item 29.
Lordship, in item 29, the IA is prayer for withdrawal of the statutory deposit, which was
Can we take it up tomorrow? Disposed of when? Okay. In March.
Lordship. Permission to withdraw the statutory deposit, which was deposited by the appellant.
But during the appellant had deposited 30% of the awarded amount, which is withdrawn. No, it's already there in the order, para 19.
Lordship, however, the registry they are seeking for.
No. See, para 19. Accordingly, the registry shall allow the respondent claimants to withdraw the statutory deposit of 25,000, which has been deposited by the appellants.
Lordship.
And the same shall be adjusted towards the payment of the balance. She is also directed to deposit the balance or the after deducting 25%. It's already there in para 19.
Lordship, it was highlighted, however, they say that without formal order. For that reason, the IA was filed.
That is the order.
Lordship. The claimant has also explained the operative part to the registry, Lordship.
Okay. The instant IA has been filed for the by the claimant respondent, claimant respondent. No. By the claimant who had, you were the appellant.
No, Lordship. I was for the claimant, Lordship.
By the claimant praying for withdrawal of the statutory deposit of 25,000, which had been deposited at the time of filing of appeal before this court. Filing of appeal, MSC appeal number 06 of 2022 before this court. Stop. Learned counsel for the applicant, Mr. Intiwapang. Stop. The petitioner submits that he had filed the MSC appeal number 6 of 2022 assailing the judgment and award dated 23/9/2021. Stop. At the time of filing the appeal, the appellant/respondent had deposited rupees 25,000 as statutory deposit as required by section 173 of the MV Act 1988. Stop. Para. The petitioner/applicant also submits that the MSC appeal 6 of 2022 was disposed of by judgment and order dated 16/3/2026. And at para 19 of the judgment, it was directed that the registry shall allow the respondents/claimants to withdraw the statutory deposit of 25,000, which has been deposited by the appellant, and the same shall be adjusted towards the payment of the balance awarded amount. Stop. The learned counsel for the applicant submits that he has not been, that the claimant has not been allowed to withdraw the statutory deposit of 25,000 by the registry of this court, and hence he has come before this court by filing the instant application. So, The court has perused the application and also the pleadings stuff. By the judgment and order dated 16/3/2026, this court had directed that the registry shall allow the respondent claimants to withdraw the statutory deposit of 25,000 which has been deposited by the appellants, and that the same shall be adjusted towards the payment of the balance awarded amount. So, this court is of the view that that this direction needs no further confirmation. Therefore, the registry shall allow the applicant/claimants to withdraw the statutory deposit of 25,000, which had been deposited by the appellant/insurance company.
Lordship.
Yes.
Lordship,
That's all. And then
Lordship, in item number 30, the appellant has deposited 50% of the awarded amount. And then the MSC appeal has been, 3 of 23 has been dismissed. So the claimant may be allowed to withdraw the 50% of the awarded amount which has been deposited earlier. The appeal was dismissed.
Present the appeal before for insurance license. But how do we know that the amount had been deposited?
Lordship,
Confused.
by order dated 11/12/23, passed in IA Civil number 130 of 23, Lordship, by this Honorable Court, the appellant was directed to deposit 50% of the awarded amount, which has been deposited, Lordship.
Do you have any details like check number or date of
At present, no,
deposit,
Your
anything?
But I have checked with the registry, Lordship. It has been deposited, Lordship.
Actually, that should have been mentioned while disposing of the judgment itself, disposing of the MSC itself, actually. The instant application has been preferred by the applicant herein.
I'm sorry for my indulgence, Lordship.
Who
It was
was-
deposited on 31/2024.
31.
2024.
2024. What did I say? Praying for who were the by the present applicant slash applicant claimant, no? Applicant claimant who were the respondents in the MSC appeal number 3 of 2023. Stop. Learned Counsel Mr. Intiopang for the applicant submits that by order dated 11/12/2023, passed in IA Civil number 130/2023, this court had directed the appellant to deposit 50% of the awarded amount with the registry. Stop. It is submitted that the said order has been complied with by the appellant/insurance company, and it has been, and the amount and the 50% of the awarded amount has been deposited with the registry of this court on 31/2024. Stop. It is also stated that after hearing the parties, the MSC appeal number 3 of 2023 was dismissed. 3 of 2023 filed by the appellant/insurance company has been dismissed. Has been dismissed by judgment and order dated 18/8/2025. Stop. However, in the judgment dated 18/8/2025, this court has not made any observations regarding the 50% awarded amount which is lying with the registry, which is lying in the registry. So, Accordingly, it is prayed that the claimants slash applicants may be allowed to withdraw the 50% of awarded amount of rupees 10, 25, 500, rupees 10 lakhs 25,500 deposited on 31/2024. So, the court has noted the submission of the learned counsel for the petitioner and perused the judgment and order dated 18/8/2025 passed in MSc Appeal number 3 of 2023. Stop. It is seen that the appeal preferred by the National Insurance Company has been dismissed by the said judgment and order. The compensation awarded to the claimant was modified, it was enhanced. It was enhanced or?
No, Lordship. It was not enhanced, Lordship.
The compensation awarded to the claimant was modified, is it?
Lordship.
Modified to rupees 16, 62, 200.
200.
Yes, 16 lakhs 62,200. To be given to be paid to the claimant at the interest of 7.5% per annum from the date of filing the claim petition, i.e. 13/9/2019. Stop. It as stated by the learned counsel. Have you enclosed the CMC IA order also here?
Lordship.
Is it?
Page number 7.
As stated by the learned counsel for the applicant, this court has also perused the order dated 11/12/2023, passed in IA Civil 130/2023, arising out of MSc Appeal number 3 of 2023. Stuff. By the order dated 11/12/2023, this court had directed the appellants to deposit 50% of the awarded amount before the registry on or before 31/2024. Accordingly, the appellants had deposited the 50% before the registry on 31/2024. So, in view of the dismissal of the appeal, MSc Appeal number 3 of 2023 by order dated 18/8/2025, the registry is directed to release the 50% of awarded amount deposited by the appellants to the claimant slash applicant after proper verification and identification by the learned counsel for the applicant slash claimant. With the above direction, the IA stands disposed.
Highly obliged, Lordship.
Yes.
Lordship, Lordship, I beg to mention item number 13, which is a delay application note. If my lord can kindly accommodate me for 5 minutes.
You have the CD.
Lord, I have this.
Otherwise, we have a hearing to be concluded. Hearing is there, yes. Can we take it up tomorrow?
Just 5 minutes, my lord. I just state my grounds for the.
No, but the thing is, from you, it may take 5 minutes, but the court has to pass the order, no? Then that will take another 20-30 minutes. Pass over, okay. Pass over. Pass over for the day.
Sorry for the indulgence, Lordship.
Item 13, yes.
I beg to mention item number 16, Lordship.
We will not be able to take up the other matters. Item 16.
Item 16. 16. It's
Yes.
a contempt matter. Lordship, I'm appearing on behalf of In Team Song, additional AG, Lordship.
Lordship, he has taken the consent of the opposite party petitioner to list the matter after 2 weeks.
Item 16, after 2 weeks, on the prayer of the Learned Counsel, Learned Government Advocate, Mr. V. Jimomi, on behalf of Mr. Im Timson. Yes.
Blythe.
Yes.
Yes, please, Your Lordship. The present revision petition 10, 11, and 12, it can be disposed of with one hearing at one go because the subject matter is
It's the same.
the same. So
And allegation is also same.
allegations are all same. Now, the case in hand are the offshoot of the order dated 2/5/2018 passed by the Gauhati High Court, that is the principal bench in PIL So Moto number 5 of 2017, whereby the order expressly directed the CBI to conduct preliminary inquiry into the allocation of the misappropriation of the public money into the construction of the High Court complex at Kohima within 3 months. On being conducting the inquiry, if any materials in support of the investigation are found, CBI was been given a direction and liberty to file appropriate FIR as per the provision of law. Now, basing on that direction, the CBI, they have conducted the preliminary investigation. And in the preliminary investigation, the money which was meant for the construction of the High Court, the irregularities in the utilization of the money was detected, and accordingly the CBI, they have registered the CBI case number as RC2 of 2019 on 17/6/2019
Yes.
under section 120P 420 read with section 13.2 and 13.1D of the PCA against 16 government employees and 4 other private persons. Now, after the investigation was completed, the CBI, they have filed a charge sheet, that is the charge sheet, in this case RC2A 2019. Charge sheet number 6 is pertaining to some other accused person, and charge sheet number 7, it is in connection with the present case which has been before the Honorable Court. So, after the filing of the charge sheet and detecting about the misappropriation of the money, the matter was taken cognizance by the Special Judge Dimapur, Nagaland, and thereafter, after taking the cognizance, the case was on proceeding. And at the time of the constitution of the charges, the petitioners, the accused petitioner here in these cases, they filed a discharge petition. However, the Special Judge CBI Dimapur, after considering the entire context of the case, has rejected their discharge petition. And after rejecting the discharge petition, since the present accused persons are private person, there was no statute of limitations under PCA, only under 420 and 120B. So the Special Judge has given a direction and relegated the matter to the Court of CGM to proceed ahead with the case after considering of the charges. So that was the order given by the Special Judge Dimapur Nagaland. So here it is one of the rare cases, I should say, and very strange. After the discharge was passed by the Special Judge CBI on 28/6/2024, the present accused petitioner, they have preferred a criminal revision under 482 CRPC, seeking the quashment of the FIR in the charge sheet filed by the CBI against the accused persons. Now, the Honorable High Court, after hearing the matter, has disposed the case on 8/4/2025. And that particular portion has already been read out by my learned friend, so just to save this, sometimes let me not make the reference.
We've already seen this.
Yes, the revision petition invoking the superintending power of the High Court was not been allowed.
My lord, it was criminal
Decline,
petition,
that means-
not revision petition. Earlier, it was
Criminal petition
It was a criminal petition.
under 482.
Yes, this is revision petition.
Yeah, this is a revision petition. But so the High Court of this Honorable Court on the earlier order has declined to interfere with the prayer made by the accused petitioner, which means it was not allowed. But in the operative part of the clause 2, Roman 2, the petitioner was given liberty to approach the court below by filing an appropriate discharge petition, if so it was. That was the indication. Now, after the case record was remanded back to the trial court for proceeding again,
No, but that chapter is closed, isn't
that
it?
chapter is closed. But here,
Because the court, this court directed them to face the CGM court
Yes.
because it was already transferred there.
yes,
Ah,
that was the case.
yes, yes.
Now, after that, they have made the counsel as well as the petitioner accused, they have entered in appearance in the trial court. Along with that, again, they have filed a discharge petition under 239, discharge petition before the magistrate. Okay. After that, the matter was been taken up by the CGM under 239. Now,
Yes.
the CGM, after considering the entire metrics of the case, facts and metrics of the case, has also come to a conclusion that there is a serious, grievous suspicion of the involvement of the present accused persons. So, the case was, their discharge petition was again rejected. Now, after rejection, I've been pointing out before this, when my learned friend was given in submission, there is no hard and fast rule, otherwise there is no part that once the discharge petition is rejected on the same day or otherwise some other consecutive day, charge can be free. Charge can be free on the same day, otherwise in any other upcoming days as per the convenience of the court. So on the same day, charge was freed. Then again, on the same day itself, since the charge was framed,
And the order framing charge, is it also on record?
yes, it's on the record.
Unit.
No, that one is no, I mean in the order sheet.
Yes, it's in the form of order sheet. It is enclosed by the petitioner also.
Annexure 12.
Page 231. 230. So,
237. Annexure 12. Type copies of 239.
in my petition as annexed, it is
Page 236, I think, 230.
in my petition it is numbered as 231 in my copy of the petition.
Yes, starts from 234. Type copy is
yes,
from
yes.
234.
Oh, I'm referring to revision petition 11, yes.
Now, after the framing of the charge, on the same day again the court has passed an order summoning the PW number 1 on behalf of the prosecution. Now, in this case, the petitioner, he has challenged the entire proceeding, entire order passed by the court. Here, why I'm saying it's a very rare, one of the rare cases. I should say in one point of, as per my submission, the principle of stare decisis may also apply in this case because special charge is the superior charge to the CGM. And the Superior Court has given a direction to the CGM Court to proceed ahead with the case. But I'd like
But
to
after that,
after the High Court
yeah.
order, again, the order clearly indicates that the order of the special judge nor the order passed by this honorable court should not influence.
Should not influence.
Now, after going through the entire materials, the colossal of evidence collected against the accused petitioner, the court has come to a conclusion that there is a serious offense. Suspicion. I would like to refer to that part of the order also. Yes, page 230. My learned friend has already read out certain relevant portions that the reasoning and decision came out by the court below. But the most important crucial portion is in 230. And you'll be allowed to read out. From the discussion above, it is clear that all that is required at the stage of framing of the charge is to see whether there is a prima facie case regarding the commission of the certain offense is made out. The question whether the charge will eventually stand proof or not can be determined only after the evidence is recorded in the case, that is, after the trial. The real test of determining whether the charge should be groundless is with whether the material are such that even if unrebutted, make out no case whatsoever. In other words, if there is a strong suspicion and material showing possibility of commission of the offense by the accused, it is sufficient for the court to frame the charge at this stage. There is no necessity for formulating opinion in any about the prospect of the conviction. In the present case, upon perusal of the charge sheet and the other materials on record, this court finds out that there are sufficient grounds for proceeding against the accused person, namely A14, A15, and A16, for commission of offense under 120p and 420. For substandard work. Now, my learned friend has been pointing out about substandard work. Okay, this is a clerical error or whatever that is, forget about it. He has not said out about this particular thing in the grounds of the revision also. But I should say, if this is error on the part of the court below, this can be rectified. No, in this case, there was no substandard work. And so, no substandard work, but incomplete construction that has to continue. Of the Blacktop Road and Baka footpath paved with checkered tiles from main highway NH61, that is Oka Road, to the main building of the new High Court complex at Mirima, Kohima, especially in respect of allegation number 6 of the CPI charge sheet number 7, 2021, thereby cheating and defrauding of the public exchequer and resulting in excess payment of to the tune of rupees 29,68,345. That is 25,89,564.75 is for the shortage of the road. Then 3,78,077 is the checkered tiles, that is footpath. In conspiracy with 6 accused engineer NBWD RNB, namely so and so, so it's named them, who are not charged since the government has declined to issue the prosecution sanction against them. So that is the finding of the court. And from the very page, that is the page 211, annexure 10, from there, the court below has analyzed the entire evidence and has come to this conclusion, and the petition under 239 was rejected. That is discharged. Now, whether they are agreed by this discharge petition or are they affected by the framing of charge, or are they affected by the issue of summon to the PW1? Here, they are trying to stall or to prolong the case from the very day. That is from the special court till the to the court of the court below CGM. That's what I'd like to pinpoint. Every order passed by the court has been under challenge. If the accused petitioner, if they feel that they are innocent, why don't they take an opportunity by facing the trial and get an honorable acquittal? But if they try to style or if they challenge every order passed by the court, court below, special court, then how can the case can proceed? The tactic applied in this case is just to stale or prolong the case. That is one aspect the court has to look into. So here, even the special court, otherwise the court below, that is the CGM, on the basis of the evidence collected by the prosecution, the cases, their petitions have been dismissed on two occasions. In the first place, I would like to make a mention is that the accused petitioner, on filing of the charge sheet by the CBI, the accused petitioner, despite of the fact that colossal evidence were brought against them of the misappropriation of public money in the initial charge petition, discharge petition, on being heard by the special judge CBI Timabo and dismissal of the discharge petition, the accused petitioner, in order to derail and fast-track the criminal proceeding, they have filed this petition under Section 482 CRPC before this honorable court, challenging the FIR as directed by the court in PIL number 5 of 2017. However, the honorable court, after hearing the criminal petition, did not incline to interfere to the appeal made by the accused petitioner, which are more or less rejected by the High Court and directed to appeal before it. Secondly, the accused person again filed discharge under 239 before the court below by exercising the liberty granted by the High Court. Whereas the court below, after considering the mammoth of evidence and the material collected by the CBI against the accused petitioner, the IA number 59, 60 and 61 of 2025, which was filed before the CGM court, was also been rejected and the charge, everything was filled. The accusation against the accused petitioner are narrated at page 87 to 105. So, for the better understanding, if the court permits me, I will be allowed to read out the allegations.
We have already seen most
Yes,
of them.
yes. But if any clarification, 16.17. That is the, it starts from there. But here certain crucial aspects are there, and unless and until I go through the context, it will be difficult to understand by this honorable court also. So
16.17.
yeah, it starts from 16.17. So whereas the, I may be allowed to read out, whereas the instant charge under charge sheet number 7 of 2021 is submitted in respect of the allegation number 6, construction of the blacktop roof and...
No, 16.17 starts with hands inspection and measurement.
Page 87.
Page 87 is 16.7.
7.
Oh. Not 17, 16.7.
Oh, I'm sorry.
16.7.
Mispronounced. Here, allegation 6, construction of the blacktop road and Paka footpath paved with checkered tiles from main highway NH 61, that is Okka, route to the main building of the High Court. This is the context. And the work order, which was then annexed by the petitioner.
Yes.
Actually, I don't want to interfere in the midst of the submission made by the learned friends. At page 55, kindly turn to page 55, annexure 1. My learned friend was saying that there was no cutting, nothing, but the work order is very clear. Page 55, subject and the part. Allotment of work for construction of High Court Road double land mini highway under Brigade 2.0 kilometer at Kohima. Brigade provided widening, new cutting, metalling, and premix carpeting and road appurtenance. These are the work order issue. So my learned friend at one point of time, there was no cutting was recorded. That is not true. The work order is very clear. I don't know how far they have executed the work, that is another aspect. But the work order is very clear that even the cutting. So 16.7, that is the...
Work order says that, of course, widening, new cutting.
Yes, but they are only saying that there was only shortage and 300 something meters.
No, but even in the charge sheet itself, it is stated
Yes.
like that.
Yes.
Only shortage of length.
Shortage. So I'm coming to the shortage. Okay, here why I'd like to come to I'm coming to this aspect is that here the petitioner as well as the CBI they are saying that 4 crore 52 lakhs 99,286. The petitioners they are also agreeing that and admitting that they have received that much amount. Even the CBI they are saying that this is the amount they have already received. And out of this, that means I want to make a reference to the country. 5 crore 81 lakh 85,000 was the country value. Now, if they executed the work, they are saying that half ton, it was only half ton for the checkered tiles and the mini highway also. They have only done half. 300 something it was.
And later only, last year they
Last year
completed.
it was. But that part I will come later at the later stage. But in 3 installment, in 3 running bill, they have already received 4 crore 52 lakhs 99,286 in the year 2011, 10, 11, and 12. Here.
No, but usually such payments, running bills,
Yes.
are made only by the engineer after measurement.
Very much. I'll come to that
So,
also.
how do the petitioners know how much has been measured and what was?
Yes,
Because it was the engineers who had done the measurement.
Here, I would like to come to that portion also because the entry, the measurement book, my learned friend was also saying that there is no requirement for the contractor to maintain their NP measurement book. It is the engineer or the other person, officials who are supposed to maintain the measurement book. Yes, but there should be a joint signature for every payment or the work executed. Those things has to be indicated by the engineer along with the contractor. Because not to disclose anything, otherwise, in order to keep the record clear, all this joint signature has to be done. But here, the measurement book was also been seized by the CBI. Entry has been totally different. In the work order, it is 2,000 meter, that is 2 kilometer. In the measurement book, it is indicated 2,010 kilometer. How comes the work order and the measurement book will differ? So, either the officials, government officials, engineer I should say, let me term it as government officials. Otherwise, the accused petitioners, they were very much aware of the measurement, how the contract was allotted. 2,000 meter only, but 2,010 meter was entered in the measurement book. So on that basis, they might have withdrawn the amount. And very crucial aspect that I would like to pinpoint here is that if the work value was 5 crore 81 lakh 85,000, and they have already received almost 4 crore 53 lakhs. Only some thousand are there.
1 crore something left.
Yes, 1 crore. Here, central sale tax, state sale tax, VAT, tax deduction, it source, forestry, seas, and it's a open secret. Taxes that is supposed to be borne. Then, if we are to assess all this, then it comes to maybe around 20 to 20 something percentage has to be put because that money they can claim after some time from the, like tax deduction, its source or others. But when the money already left is about to cover up the other expenses like tax, that, whatever, from where they have said that the remaining part of the money is yet to be received. That remaining portion, I would say, and I'm giving this indication, why is that? Remaining 1 point something. The workout that I've made is 22.25% has been deducted. So, Sandra, kindly make that reference, note. There are so many taxes. State sale tax is 12% at that relevant point of time. Central sale tax was 4%, 16 point. C's is 1%, 17. Then tax deduction its source, it is 18%. Then forest royalty from the state government and other taxes, if we are supposed, you don't have any money to be, the amount that which has already been left in the exchequer, that is to be found for the covering of the other taxes, whatever taxes that I'm mentioning. Now, the CBI is saying that out of 4 crore 52 lakhs something, from there 29 lakhs was been misutilized or misappropriated, misused. Now, how that it was done? The measurement book, the entry in the measurement book is totally different from the work order. So, that is one aspect. Second aspect was that they are saying that they have not completed the work. If they are not completed, and the work period was only for 12 months, my learned friend has been giving a submission that it was stopped. Who has given a direction to stop? No documents to prove that the ongoing work, unless and until the High Court construction has completed the road or the checkered footpath, it should not be constructed.
No, but practically you also think about it.
Yes.
Because we have also been there many times.
Okay.
So construction was going on. How could the road have been made encircling
Yes,
road?
that-
Okay, footpath maybe they could have done it, but the encircling road, that is not possible.
Yeah.
Only now after the building was completed, they have made it.
I agree to that, what the Lordship point out also. So, if we are to assess with the amount that they have already received, the amount that they are yet to receive, and the taxes that is supposed to be covered up, how can they say that the remaining part of the road was not completed because of the High Court construction, so and so? So the remaining part of the money is lying with the government exchequer. That is one aspect that has to be taken into consideration.
My Lord, very quickly, in paragraph 16.28, it is clearly mentioned that third running account bill is 4 crore 81 lakhs 1,570, and we have received, after deduction of tax, 4 crore 52 lakhs something. So,
that
this
indication is
1
not
crore
given anything anywhere.
91,000 something, it is pertaining totally to the remaining portion of the work. That is what I want to say.
Yeah, that is the contingent here.
After taxes, about 30 lakhs have been
Now,
deducted
what
in
you
taxes.
can do is, after the hearing, you can give written submission sort of thing, explain.
Please, yeah.
Because since it involves figures.
Yes, and it's clearly reflected in 16.28 of the charge sheet.
Okay,
the amount.
we will continue tomorrow, okay?
Yes, yeah.
Heard Learned Counsel, Mr. Sintianga for the petitioner, also heard Learned Counsel, Learned PP for the CBI, Mr. Pandamapa. So, matter is part heard. This tomorrow as a part heard item at the top of the admission list.
I am deeply obliged.
एक पटक थोड़ा लगे ना